President Trump seems to be getting ready to dismantle executive agencies by signing an executive order. U.S. aid has been administering billions of dollars annually for many years, and Trump has felt for a long time, he's expressed his belief that the money that's given out is not being allocated first and foremost with American interests in mind. So, our question is, can President Trump dismantle these agencies by himself, by executive order, and without Congress? Let's back up. What is an executive agency and how are they created? Well, being that they are executive agencies, they are under the executive branch. They're technically under the president's domain, and there are many, many executive agencies from the Department of Health, Department of Transportation, Department of State, Department of Commerce. The secretaries of these agencies are nominated by the president, but then they need to be approved by the Senate. The very first executive agency was actually the Department of State, which was established in 1789. That year, Congress created not only that one, but also the Department of Treasury and what was originally known as the Department of War. The Congressional Research Service, sometimes known as CRS, is a public policy research institute that's lodged within the Library of Congress. It puts out publications primarily for members of Congress and their staff. They try to provide independent research and information to public officials in a nonpartisan way to give them the knowledge and the background they need to go in and make important decisions in the government. It was formed in 1914 and it's been putting out publications now for over 100 years. And they put out a report on June 27th, 2018 called Organizing Executive Branch Agencies, Who Makes the Call? And there's a whole section called Constitutional Principles. And in it, they say that Congress may act pursuant to its enumerated powers in the Constitution and has some leeway to act as well due to the necessary and proper clause in the Constitution that helps Congress kind of do what it needs to do, passing legislation to assist in the execution of other provisions of the Constitution, including aiding the president in carrying out his own congressional duties. So it says that agencies created by Congress generally are limited to taking actions authorized by law and have to comply with statutory restrictions placed on those agencies' scope and structure of authority. So the Constitution separates power to create the executive branch offices. So Congress has a lot of power here in authority over the structure and functions of executive agencies. There is an appointments clause of the Constitution providing that principal officers that are not expressly mentioned in the Constitution, those who exercise significant authority and report directly to the president, have to be appointed by the president and confirmed by the Senate. And lower officers, Congress may by law place inferior officers with the president alone, a department head, or a court of law. Congress establishes executive branch offices via enacted legislation, but places the power of appointment of the heads of executive branch departments with the president, subject to Senate confirmation. Therefore, the Appointments Clause offers another constraint on the president's authority, his ability to reorganize the executive branch without congressional authorization. Any reauthorization plan that aims to unilaterally create a freestanding constitutional office will likely require additional legislation to implement, meaning you need to get Congress on board. And that office must be headed by an officer appointed by the president who is confirmed by the Senate. In fact, the publication here notes that the executive branch itself concluded in the 1980s through the Department of Justice that the president generally lacks independent power to create a new federal office headed by a principal officer. So individual agencies are allowed to and often do reorganize themselves within the statutory limitations that are placed upon them by Congress. But anything more than that, you're going to need to get Congress directly involved. The CRS notes that authorizing legislation has been understood as necessary for government-wide reorganizations, which involve, for example, transferring entities from one agency or department to another, or combining two or more agencies into a newly created department. In 1926, the Supreme Court issued a decision, Myers versus United States, and this was the first Supreme Court case to address the president's removal powers. In the Myers decision, the Supreme Court voided a legislative provision that had restricted the authority of the president to remove or replace certain postmasters without the consent of the Senate. There was an 1876 law that basically said that postmasters can be appointed and may be removed by the president, but in both cases, only with the advice and consent of the Senate. And President Woodrow Wilson tried to remove Myers, who was a postmaster, without seeking Senate approval. The Senate got all upset, and it goes up to the Supreme Court. And the Supreme Court says no, he had the right to do that. The president needs to get the advice and consent of the Senate to appoint these people, but not to remove them. Okay, what about just executive presidential reorganization authority? Well, the Congressional Research Service put out a position paper on this as well on December 11th of 2012. And this was in response to an announcement from the Obama administration. In January of 2012, President Obama announced that he was going to ask Congress to reinstate what was known as the Presidential Reorganization Authority. And his administration had put a proposal on the table to have Congress renew this power. The president wanted this power because he wanted to consolidate 6 business and trade related agencies into one: the U.S. Department of Commerce's core business and trade functions, the Export Import Bank, the Overseas Private Investment Corporation, Small Business Administration, the U.S. Trade and Development Agency, and the Office of the U.S. Trade Representative. He was also going to kind of move some smaller things around. He said, for example, the National Oceanic and Atmospheric Administration would be moved to be housed within the Department of the Interior. And the research, the CRS paper here goes in great detail about how between 1932 and 1981, Congress would periodically delegate authority to the president that allowed the president to develop plans for reorganization of positions of the federal government and then present those plans to Congress for consideration under congressional procedures. Under these procedures, historically, the president's wishes would happen unless Congress would exercise a legislative veto. The president's plan would go into effect unless one or both houses of Congress passed a resolution explicitly rejecting that plan. Now, obviously, this setup favors the president because Congress can be asleep, and if Congress doesn't act, the president gets his way. But this comes kind of to an end in 1984, where this mechanism is amended, and the burden of power, it shifts. So now Congress is required to act affirmatively in order for a plan to go into force. So this obviously shifts the balance of power to Congress, that the president can't do what he wants unless Congress explicitly, affirmatively gives him the power to reorganize. And many presidents, not just President Obama, many presidents had tried before to push the limits to get this back, and it did not work. Between 1932 and 1984, presidents used this presidential reorganization authority regularly. They submitted more than 100 plans. And for a variety of reasons, from relatively minor reorganizations within individual agencies to the creation of large new organizations, such as the Department of Health, Education and Welfare, the EPA, the Environmental Protection Agency, and the Federal Emergency Management Agency. So really at the beginning, this all goes back to 1932. Herbert Hoover had been a big proponent of the idea that Congress should delegate to the president authority to propose reorganizations of the executive branch for the purposes of improving the economy and government efficiency. And in 1932, Hoover requests this power, and a few months before the 1932 presidential election, Congress provides the first version of the President's Reorganization Authority. So under this act, the president was authorized to direct by executive order specified government reorganizational actions. These executive orders were subject to congressional review, and they could be nullified by a resolution of disapproval within 60 days by either chamber of Congress. So Hoover issues a number of executive orders under the authority of this act, and they directed the consolidation, coordination, and grouping of specified agencies and activities according to the major functions and purposes. As the administrations go on, the presidents go on, they all kind of ask for similar powers, and it goes back and forth with Congress, and they're basically given what they want until we get to Jimmy Carter. When Jimmy Carter runs for president in 1976, his campaign described the federal government as a horrible bureaucratic mess. And it suggested that a Carter administration would give top priority to a drastic and thorough revision of the federal bureaucracy. Jimmy Carter on the campaign trail indicated that if he was elected, he would ask for complete authorization to reorganize the executive branch of government, giving him as much authority as possible. And with that authority, he would use to work toward the elimination of unnecessary agencies and departments, regulations, and paperwork. If elected, he said, I pledge to have a complete reorganization of the executive branch of government, making it more efficient, economical, purposeful, simple, and manageable for a change. So he takes office and he requests a renewal of the Reorganization Act of 1949. He sends a message to Congress in 1977, and Congress basically goes with the flow. But then, in 1979, the Carter administration conveyed the president's intention to create a new Department of Natural Resources. And this proposal really faced a lot of congressional backlash. Because of this backlash, there were no related reorganization plans that were submitted by the Carter administration. Then we get to Reagan. The extension of the Reorganization Act under President Carter expired in 1981. And these are the early days of the presidency of Ronald Reagan. There were efforts made by his administration to extend and modify the authority again. But in 1981, although the legislation supported by the Reagan administration was passed in the Senate, it was not passed in the House. In 1983, the Supreme Court in INS v. Chadha struck down the legislative veto as unconstitutional. After that, different administrations tried to get Congress on board, but haven't had much success. The Reagan administration, as part of fiscal year 1986 in its budget request, which was submitted in 1985 for the 1986 budget, the document went on with a long history of the president's authority to do these kind of things, the opportunity to use the authority that had been granted. The request stated that the president will propose renewal of the reorganization authority to permit continued structural flexibility. It didn't go anywhere in the legislature. From 1989 through 2010, decades passed. George W. Bush didn't seem to try to get this power back until 2003, where he said that his administration was going to seek to reinstitute the permanent reorganization authority of the president to permit expedited legislative approval of plans to reorganize the executive branch. And it looked promising in the House, but the provisions were removed when the House was in conference with the Senate. They were not included in the final bills that became law. Okay, and then we get to Obama in 2012. He also wanted this, he proposed a legislative proposal that would renew the president's reorganization authority. And what is 100% clear from this position paper on presidential reorganization authority is when they are talking and putting out these memos to the people in the elected representatives in the Senate, in the House and the Senate, it's very clear that Congress holds the cards. There's a section at the end talking about potential approaches for congressional consideration. And it says, President Obama has requested a renewal of the Presidential Reorganization Authority. A bill has been introduced in the Senate that would grant him power in a modified form. It says Congress might approach the question of whether and how to delegate this authority to the president in various ways. And it goes through it, but it's clear with all of these suggestions, it's clear that Congress has to act affirmatively. Okay, one more very important paper that was issued by the Congressional Research Service, and that came out in January 10th of 2024. This one deals with abolishing a federal agency. We talked before about reorganizing it, but have we faced the question before from a constitutional analysis about abolishing it? And it talks about how the ICC, the Interstate Commerce Commission, was set up in the 1800s to kind of regulate the railroads and make sure that prices weren't being manipulated and people weren't being manipulated. And it was relatively weak in terms of the power it actually had. It could only make certain findings. It was like quasi-judicial, but then it had to kind of refer supposed violations to U.S. attorneys or to U.S. circuit courts. And eventually, the ICC was discontinued. So this position paper talks about how Congress from time to time has enacted legislation to consolidate or discontinue a federal agency and either redistribute, or discontinue its functions. And it decides to focus on the ICC because it says that it is perhaps the quintessential example of the abolishment of an agency and discontinuation of many of its functions. From the 1800s until the 1900s, a lot changed with regulations, with government, with railroads. And in 1969, President Nixon establishes an advisory council on executive organization, sometimes known as the Ash Council, and its purpose was to assess executive branch arrangements and offer proposals for improved organization. And one of the main things that group found was that the ICC was not sufficiently accountable for their actions to either Congress or the president. They were operating too independently from the other structures of government. Specifically with the ICC, the Ash Council proposed that the ICC be abolished and the regulatory responsibilities be combined within a new transportation regulatory agency that would be headed by a different administrator. And among other things, they basically said, look, the ICC was created to be this quasi-independent agency to counterbalance the powerful railroad industry that was almost operating like a monopoly back in the day. But by the 1970s, people had cars, people had the options to fly. Railroads were in decline. And the ICC's regulatory role was probably not needed anymore, definitely not the way that it was in the past. So, as a result of this, there was legislation that was introduced to abolish the ICC, but it never really gained traction until the 1990s. In 1995, President Clinton worked with Congress to come to a bipartisan agreement to abolish the ICC. In fact, in his 1995 State of the Union address, President Clinton called for spending reductions, cutting outdated and unneeded programs like the Interstate Commerce Commission, and getting rid of unnecessary regulations and making them more sensible. So what he wanted to do, his proposed budget for fiscal year 96, he called for the phasing out of the ICC by eliminating most remaining motor carrier regulatory functions and some rail functions that have outlived their usefulness. And he said if anything was left in the ICC's domain that was not eliminated, that should be transferred to the Department of Justice or the Department of Transportation or the Federal Trade Commission. And by the end of 1995, the House and Senate had each passed ICC termination legislation. That resulted in the ICC Termination Act of 1995, which was enacted on December 29th of 1995. And this position paper says also that looking at this, it becomes clear, as they put it, considerations for Congress, again, talking to the congressmen and congresswomen, says as the central actor in the establishment and reorganization of executive branch institutions, policies, and processes, Congress has sometimes abolished agencies and their functions. And should Congress elect to consider legislation to eliminate additional federal agencies and functions, the history of the ICC might provide useful information about these issues that could arise. Later on, it also says, primary constitutional responsibility for the structural organization of the executive branch, as well as the creation of the principal components of that branch, rests with Congress. There's a footnote, footnote 151. It says Congress, in exercising its powers to legislate under Article 1, Section 8 and other provisions of the Constitution, is empowered to provide for the execution of those laws by officers appointed pursuant to the Appointments Clause, Article 2, Section 2, Clause 2, and in addition, under the Necessary and Proper Clause, Article 1, Section 8, Clause 18, Congress has the authority to create and locate offices, establish their powers, duties, and functions, determine the qualifications of office holders, prescribe their appointments, and generally promulgate the standards for the conduct of the offices. So what's 100% crystal clear from all of these papers and from all of the constitutional analysis that's been provided is that Congress needs to act. The president cannot take an executive order, sign with with his pen, and abolish an executive agency. In 2017, the Heritage Foundation, which is considered a right-wing think tank, put out a piece called The President's Reorganization Authority. And in it, they made it very clear that the president may be able to accomplish some reorganization goals through particular statutory delegations of authority, executive orders, department memos, management policies, and other devices. But, it says, to accomplish major reorganization objectives, he will need explicit authority, statutory authority from Congress. The piece says that the president has no statutory authority to reorganize the executive branch except where acts of Congress delegate authority to make those particular changes. He can suggest things, he can put a task force or a commission together to study the executive branch concerns, to recommend changes to Congress, but he needs Congress to actually be the ones to give him the power to do anything. He talks about how Article 2 of the federal Constitution does not grant the authority to reorganize the executive branch on his own, because the executive vesting clause specifies that the executive power shall be vested in a president of the United States, but the case law makes clear that for entities that were created by Congress, the power to enact, amend, or abolish these executive departments and agencies and their functions belongs to Congress. Interesting also to note, July of 2021, the Federalist Society puts out a publication called The End of Independent Agencies, Restoring Presidential Control of the Executive Branch. And they talk about how when President Joe Biden took office, he was exercising too much control, too much executive control by firing the general counsel of the National Labor Relations Board and removing the Social Security Administration commissioner. The article says that it's typical that obviously presidents come in and they want their own people to be running their own agencies, the people who share their policy visions, but it says that these personnel moves differed in kind from those of Biden's predecessors going back nearly a century, because these boards, these agencies, were typically regarded as independent, standing outside of the usual department structure, and insulated from the president's direct control through statutory restrictions on removal. And the article says that removing the commissioner and the general counsel, these moves were unprecedented. However, they do acknowledge that President Biden's actions may find support in a recent line of Supreme Court precedent that has revived the president's inherent removal power as an aspect of the executive power vested in him by the Constitution. In deciding these cases, the article says, the court has cast doubt on Congress's power to cut the president out of independent agencies' affairs by constraining his ability to remove and thereby to control agency officials. So now let's go back to our original questions about what Trump can do with U.S. aid and with the Department of Education. Well, let's start with the Department of Education. It was established in 1979. And it's interesting because under the Constitution, it's pretty clear that education is in the purview of the states. But what the federal government can do, the Supreme Court has said it can do, is offer incentives to the states, like carrot on a stick, where it can say, we will give you grants, we will give you money if you, the states, put this in your education curriculum or test this with standardized tests or things like that. And so the Department of Education traditionally has overseen funding for public schools, it has administered student loans, and has run programs to help low-income students. It was established in 1979, but as early as 1980, in President Ronald Reagan's campaign, he pushed for it to be dismantled. So this idea is not new. And a draft of Trump's executive order to dismantle the Department of Education acknowledges, at least tacitly, that only Congress can really completely get rid of it. What it does mention is that the executive action could direct the agency to begin to wind down. That's the text of the executive order that it seems will be put forward to the president to sign. The planned order would direct his education chief to start winding down the agency and urge Congress to pass a measure abolishing it. There actually was a bill floating around the House in 2023 that would have closed the agency, but at the time, 60 Republicans joined with the Democrats in opposing it. So it seems pretty clear that even Trump and his inner circle understand that the most he could do with an executive agency is begin to wind it down and urge Congress to close the agency's doors for good. Now, what about U.S. aid? We said that if Congress creates an executive branch, Congress has to be the one to dismantle it. But U.S. aid was created by an executive order. It was issued by President John F. Kennedy in 1961. However, here too, President Trump cannot abolish U.S. aid with an executive order by itself. And that is because there was a later act of Congress in 1998 called the Foreign Affairs Reform and Restructuring Act that established U.S. aid as its own agency. And it says clearly in there, unless abolished pursuant to the reorganization plan submitted under Section 6601 of this title, and except as provided in Section 6562 of this title, there is within the executive branch of government the United States Agency for International Development as an entity described in Section 104 of Title V. The key language here is that there is within the executive branch of government. These words are what Congress uses to establish an agency within the executive branch. And that means since Congress established it in 1998, the president now may not unilaterally override the statute simply by an executive order. What Trump may want to do, at the very least, is not funnel money into U.S. aid. Can he do that? Could he refuse to spend the agency's money, foreign aided funds that were allocated by Congress? Congress is in charge of taxation and spending. If the president would do that, though, he would likely face a conflict due to the Impoundment Control Act of 1974, which requires the president to get permission from Congress to withhold discretionary spending.